Hi, everyone. Welcome. I am not an actuary. I am a law professor, but hopefully we'll have some fun stuff to talk about today. For the past decade, the Affordable Care Act has been a central element of American legal discourse. For you, in particular, the ACA litigation has created something you don't like, which is uncertainty and doubt. Actuaries like certainty and doubt. But when we're dealing with judges and lawyers and the Constitution, we have uncertainty. So my goal for today is to walk you through, if I can, a decade of Obamacare litigation. I've written now 2 books on the Affordable Care Act. The first one in 2013 was called Unprecedented. The second book was written in 2016 called Unraveled. And I'm working on the third book, the trilogy, which should be coming out next year or so. It'll be called Undefeated. So let's start back in 2009 and 2010. As many of you probably recall, President Obama made it his goal, his singular achievement, to pass healthcare reform. Back in 2009, it became clear that Republicans in Congress were not going to support this law. At the time, the Democrats had a 60-vote majority, and they were content to pass this on a straight party line vote, which has consequences. The consequence was half the country really didn't like this law. Almost immediately after President Obama signed the bill, it was challenged as being unconstitutional. I apologize if there's a bit of a lag. I think there might be. I'm sorry. Doing the best we can here. In 2009, the law was enacted. The law was enacted in 2010, and there was an argument that the law was unconstitutional. Why? The ACA was a unique statute. It required people to purchase health insurance. And the question arose, did the federal government have the power to compel people to buy health insurance? This case went up and down the courts. Let me stop my camera for a second, and that might help reduce the lag. Just 1 second. All right. Is that any better? No? Such a Zoom. So in 2012, the case goes to the Supreme Court. And the court holds that Congress cannot make you buy insurance. But the court also holds that Congress can impose a tax on the uninsured. This was part of Chief Justice Roberts' famous saving construction. The Chief Justice found a way to save the law. He says, you can't make people buy insurance, but you can tax them for going uninsured. And with this sleight of hand, 5 justices saved Obamacare. Had the Chief Justice not did what he did, part or perhaps all of Obamacare would have fallen out back in 2012. But the law survived. The ACA's second big existential challenge came a couple years later with a case called King versus Burwell, which you may be familiar with. The ACA established healthcare exchanges. There was going to be a federal exchange, and states also the option of making state exchanges. States that did not build an exchange, people in those states could rely on the federal exchange. But there was a problem. The statute that created these exchanges said that funding is available for exchanges established by the state. Right? That's what it says in the statute. Funding is available for subsidies on exchanges established by the state. About 24 states never actually built exchanges. So was there funding available? Once again, the case goes to the court. By this time, the ACA had already been sort of integrated into our polity. And if people on people on the federal exchange lost their funding, it would have made things much worse. Once again, the Supreme Court ruled in favor of Obamacare. The court said, well, yes, it says funding is available on exchanges established by the state. But if you read the entire statute, it becomes clear that the actual exchanges they're talking about is either state or federal. I won't bore you with the details. Needless to say, I am not persuaded. But once again, Chief Justice Roberts wrote the majority opinion, saving the ACA from an existential challenge. This brings us to 2016. At that point, I thought, okay, we've had a good few years run. This Obamacare litigation has to draw to a close, right? We can't be litigating Obamacare forever. How many books can I write about this? One more would come. In 2017, President Trump's inaugurated. There's a Republican Congress. And they try to repeal the Affordable Care Act. In a very famous moment, Senator John McCain of Arizona put his thumb down and killed the Obamacare repeal effort. But they weren't done. Later in 2017, the Republicans in Congress were working on the Tax Cuts and Jobs Act, this massive tax cut platform, the TCJA. I'm sure you know this all too well. This bill cut taxes in many regards, but it also made one very important change to the Affordable Care Act. You see, when Congress passes budgetary legislation, like tax legislation, there's no filibuster. They don't need 60 votes in the Senate. They need only 50 votes in the Senate. And one section of the of the TCJA, the Tax Cut Act, modified Obamacare. What did it do? The ACA has a component that says if you don't buy health insurance, you'd have to pay a penalty. The penalty was about $700, depending on a few factors that are not very important here. In the Obamacare decision from 2012, the court said, well, that penalty of $700 looks like a tax, so we will uphold the law. In other words, that statute was barely constitutional, sort of dangling by a thread. That $700 penalty was what saved the law from being set aside in 2012. So what did Congress do? They reduced that penalty to $0.00. Congress did not actually affect the requirement to buy insurance. All Congress did was they set the penalty to $0.00. So what does that mean? Right? If the penalty is $0.00, is Congress still using its taxing power? And if Congress is not using its taxing power, aren't we left with an unconstitutional mandate to buy insurance? Well, this idea was not lost on my home state of Texas. And our Attorney General and some other private parties sued the federal government, the Trump administration, for having an unconstitutional law. That is, Obamacare could no longer be saved. Obamacare can no longer be saved because the penalty was $0.00. Okay? So what does this mean? The court always intervened. The trial court, as a judge in Fort Worth, said that the entire Obamacare law was now unconstitutional, root and branch, the entire thing. This made all the actuaries lose their mind. You guys, the head starts spinning. You couldn't deal with this sort of uncertainty. This created severe instability in markets across the world. The judge put his ruling on hold, though, and it went to the Court of Appeals. And before the Court of Appeals, the court said, well, maybe not all of Obamacare is constitutional, but parts of it are. And we're not really sure which ones. We'll think about it some more. And then the case goes to the Supreme Court. It was argued in November of 2020, a couple days, or was it right around the presidential election? Might have been plus or minus a few days. By that point, Justice Amy Coney Barrett was on the court. She had replaced Justice Ruth Bader Ginsburg. So on paper, at least, you had a 6-3 conservative court. But to be perfectly candid, no one really expected the Supreme Court to kill all of Obamacare. Even me, who I filed a brief in support of the challengers, I didn't expect it to actually work. I was pretty certain that the court would find a way to avoid this case. And that's basically exactly what they did. By a 7-2 vote, the court threw away the challenge. But they did so on what you might call technical grounds. And I need to give a little bit of law here. I'm sorry, but I have to. No one can go to federal court because they don't like a law, right? That's not enough. You can only go to federal court if you have what's called standing. That is the ability to challenge something in court. And standing has 3 elements, right? First, some law has to injure you, right? You have to be injured by a law. Second, your injury can be traced to the enforcement of that law, right? So there's actually a connection between your injury and the law. And third, the courts have to be able to issue some sort of remedy to fix your grievance, right? To redress your complaint. The Supreme Court only addressed the second of these factors. The court didn't address injury. The court didn't address redressability. So who were the judges of the majority and the dissent? Well, in dissent, you had Justices Alito and Gorsuch. They were in dissent. We'll get to the dissent in a minute. The majority was by Justice Breyer, not by the Chief Justice. This was the first Obamacare case Roberts didn't write. So you had Justice Breyer, Chief Justice Roberts, Justice Sotomayor, Justice Kagan. We also had Justice Thomas, not the justice you expect in the majority, but he ruled with the majority. And you had Justices Kavanaugh and Barrett. So 2 of the Trump appointees plus Justice Thomas were in the majority. This was a sign that things were not as perhaps some conservatives had hoped for. Let's walk now through the majority opinion. I apologize. There's some thunder in the background. If my thing goes off, we'll have to improvise. But the weather gods are not complying with my talk today. All right. So again, the majority rules that the traceability aspect of standing is not satisfied. And there were a couple different theories of why the plaintiffs had standing, right? The first theory concerned private plaintiffs. These were 2 Texans, 2 citizens in Texas. And they argued, look, even though the penalty is $0.00, I am still subject to a requirement to buy insurance. So the argument goes, well, what happens if you don't buy insurance? Well, nothing happens to me, but I'm still subject to that requirement. The court said, no, this is not going to fly. A law with a $0 penalty is not actually enforced. And because the law is not being enforced, there's no link, there's no causation between your injury and the law, right? You can't just complain about a statute in the book because it's in the books. You have to show this linkage. Therefore, the private plaintiffs can't trace their injuries to any action from the government. There were also state plaintiffs, right? The state of Texas and Louisiana and a few others were suing. What happened there? Well, the states argue that because the penalty was reduced to zero, more people might enroll in Medicaid. And if more people are enrolling in Medicaid, that will increase the state's cost. The Supreme Court said, no, this argument's not going to work. You haven't showed any evidence that the elimination of the penalty will make more people enroll in Medicaid. Frankly, if to the opposite, right? If people for whatever reason have no penalty, they're less likely to go on Medicaid and have insurance. Okay. So in all regards, the court held that there was no connection between the injury claimed and any sort of governmental action. And that was it. The majority opinion was about 12 pages long. Very short for Supreme Court opinions. These are 100-page opinions. Very short. The court did not address whether Obamacare is constitutional. They did not address whether the law could still be saved as a tax. All the court held was that these plaintiffs do not have standing to bring the claim in federal court. No more, no less. So does that resolve the constitutionality of Obamacare? Are my actuarial friends calm that there's certainty and that the ACA is on solid footing? If there's the thunder in the background, that means the answer is no. The ominous clouds on the horizon. There will be more, my friends. There's more. And let me explain how this works. What the court held is that people can't go to court to challenge Obamacare. They don't have standing. Fine. But what if someone is being prosecuted for violating the ACA? For example, what if a person is charged with committing fraud, healthcare fraud, health insurance fraud, and they violate some provision of the ACA? The government comes after them, say, you owe the government money for committing fraud. Right? It happens. There are lots of these types of suits. And then the defendant says, wait a minute. You can't do this because Obamacare is unconstitutional, right? You are enforcing an unconstitutional law against me. At that point, the court would have to assess, is Obamacare constitutional or not? And the court would have to decide, can the mandate still be saved with a $0 penalty? So this legal cloud, which looks like the cloud outside my window, is not gone. It still sort of looms on the horizon. Might be this year, might be next year, I don't know. But some lawyer somewhere will be smart enough to figure this out. And maybe the court will have to take this Obamacare case one more time. I'm going to start a fourth book of that. I hope not. So the majority sort of punted on the issue. And they didn't decide the legality of the ACA. All right, now let's go on to the other opinions. Justice Samuel Alito dissented, and he was joined by Justice Neil Gorsuch. The dissent was nearly twice as long as the majority opinion. Justice Alito was not happy. He seemed very upset. He said, this case, quote, follows the same pattern as installments 1 and 2 of the epic ACA trilogy. He called it the ACA trilogy, kind of like my books. He was giving me a plug. Alito wrote, in all 3 episodes, with the ACA facing a serious threat, the court has pulled off an improbable rescue. The dissent argued that the state plaintiffs had standing, the mandate's unconstitutional, and the court should enjoin those provisions. So let me walk you through Justice Alito's dissent. He focused entirely on whether Texas and other states had standing. Okay. He said the states have offered plenty of evidence to show that they will incur expenses to comply with the ACA. He said there's no question that they've demonstrated their injury in fact. All right. I'll give you a few examples. The ACA imposes reporting requirements on the states. And the failure to comply with those requirements can result in heavy penalties. These penalties inflict an injury that can be traced to the government's actions. Thus, you have an injury and traceability. And you can redress those injuries. You can address them by halting the reporting requirements. Justice Alito wrote that the majority simply ducks these issues based on a fundamental distortion of the court's standing jurisprudence. These are very harsh words. The dissenters were not happy. Okay. But this was the disagreement about standing. Next, the court moves to whether, the dissent moves to whether the mandate itself is unconstitutional. We know from 2012, in the first Obamacare case, that the individual mandate was not a valid exercise of Congress's power to regulate interstate commerce. Yet in 2012, a majority held that the mandate represented a lawful exercise of Congress's taxing power, in part because the penalty raised revenue, generated some money. But in 2017, the penalty was reduced to zero. It no longer raises revenue. Alito notes that the court is presented with the daunting problem of a tax that does not tax. Justice Alito asked rhetorically, can the taxing power which saved the day in the first episode sustain such a curious creature? No, he answered. The slender reed that supported the decision in NFIB was seemingly cut down by Congress. Now, the penalty cannot raise a cent. And the saving construction from Chief Justice Roberts no longer holds. The taxing power argument that garnered 5 votes in 2012 is no longer defensible. Therefore, he said the court should stop the Obamacare provisions that burden the state plaintiffs. What are those provisions? They're the provisions that are inextricably linked to the individual mandate. The dissenters didn't say what those provisions are, right? They didn't actually do the dirty work of saying, we have to stop this provision and stop this provision, stop this provision. Imagine like going through a statute with a red pencil and say, yep, strike this, strike this, strike this, strike this. Enough to drive people crazy, right? They said, just the provisions that are burdensome. We don't know what those are. This position represented a retreat for Justice Alito. In 2012, he would have declared the entire Obamacare law unconstitutional. But in 2021, he only limited the remedy to provisions that injure the plaintiffs. But he did not explain with precision what those injurious provisions were. And then we get to Justice Thomas. Now, you guys may or may not know much about the Supreme Court, but Justice Thomas is consistently ranked as the most conservative justice. He was to the right of Justice Scalia. People often said that Thomas followed Scalia. No, it's the other way around. Scalia followed Thomas, right? Scalia would say, he's to the right of me. This guy's crazy. I have to pull him back sometimes, right? But Justice Thomas joined Justice Breyer's majority opinion. But that join seems somewhat begrudging. Justice Thomas regretted that in the past, the court had gone to such great lengths to rescue the ACA from its own text. But in this case, it's different. In this case, it's different. The plaintiffs have not identified any unlawful action that has injured them. Here, the court was not once again rescuing the act, but instead was simply adjudicating the particular claims the plaintiffs chose to bring. Justice Thomas found that none of the parties had standing. The private plaintiffs alleged only harm caused by the bare existence of an unlawful statute that does not impose any obligations or consequences. And the state plaintiffs claim harms flowing from enforcement of certain parts of the act, but they attacked only the lawfulness of a different provision. In other words, the states are not injured by the individual mandate. Thomas wrote that none of these theories trace a clear connection between injury and unlawful conduct. In the end, Justice Thomas cast the seventh vote against the plaintiffs. Justice Alito sounded embittered by the majority opinion. He lamented that once again the court has found a way to protect the ACA. This third challenge, the ACA is over, but a fresh round of litigation is inevitable. Justice Alito observed many other parties will have standing to bring such a claim based on a variety of the ACA's provisions that cannot be severed from the mandate. He predicted that our Affordable Care Act epic may go on. Soon enough, the trilogy will become a quadrilogy, and I'll be here to write about it. All right. Thank you so much for your attention. I know we'll be taking Q&A later, and I'm very eager to hear what my other colleagues have to say. Thank you so much.
All right, I think I'm on. Thank you very much, Josh. I'm gonna, I think, try to explain this from an actuarial perspective. We've titled this the ACA Supreme Court and What Actuaries Need to Know. When we initially came up with the concept for this session, we were perhaps thinking